Hello, everyone. Welcome to another public lecture of the 21st Century China Center. This is, of course, as you all know, the 21st Century China Center is based in School of Global Policy and Strategy at UCSD. The GPS, as we call ourselves, offer a range of programs, mainly at the master's level, including the Masters of Chinese Economic and Political Affairs, the MCPA program. The 21CCC is an academic institute that tries to also inform the policy circle, and we do a lot of bridge building activity with our counterparts in China as well. For those of you who don't know, I think most of you know, I'm Victor Shi. I'm the director of 21st Century China Center and the Ho Mill Chair in China and Pacific Affairs. We're very honored to have Nason Mahboubi today to talk about China's legal development in the past 10 years. Nason is currently director of the Penn Project on the future of U.S.-China relations at the University of Pennsylvania, where he teaches various courses related to Chinese history, law, and policy. Previously, he was a research scholar of Penn Center for the Study of Contemporary China, and he continues to host the CSCC. But of course, we all know him as the chair of Zhengfa Wei, which is an occasional Twitter Space podcast speaking series where we just get together and banter about various topics on contemporary China with a guest, and we've had a whole range of guests, and hopefully we'll do another Twitter Space at some point soon. And besides joining each other virtually, we also get to find opportunities to join each other in person. So this past week has been a Zhengfa Wei week. It's like our National Party Congress time where we met in DC, and then now we're meeting here. So it's a great honor to have you here, and I look forward to your talk.
Thank you. Thank you so much. It's a real pleasure and privilege to be here. I should say that, we always laugh when we say Zhengfa Wei, because obviously it's a play on the actual Zhengfa Wei, the Central Political and Legal Affairs Commission, which at one time was led by the fearsome Zhou Yongkang. This grouping, which of course includes Professor Shi, and also in the audience with Professor Isa Ding from Northwestern, and some other friends who are in town this week, has been one of the delights of the last couple of years for me personally, to be able to chat with them on a regular basis in this public forum that we get to talk to different experts on Chinese politics and law. And I think we're all kind of committed to developing it further, because one of the things that I think it does really nicely is that it enables us to take pretty sophisticated work on those topics of Chinese politics, Chinese law, Chinese society, Chinese economics, and share it with wider audiences in ways that are maybe a little bit more accessible than our pure academic work, but are still maintain the integrity of our academic values. And they're just a lot of fun. And one of the things that I've always enjoyed is just the name of our group, the Zhengfa Wei. Maybe we'll get in trouble for this someday, but as of right now, if you do a Google image search for Zhengfa Wei, of the first 25 hits, maybe 22 are pictures of our programs or pictures of ourselves, and then the remaining 3 are like Meng Jianzhu and Zhou Yongkang. So, maybe someday we'll get in trouble for that, but I think it's helped that the Zhengfa Wei itself, the real Zhengfa Wei, was downgraded after, I think, the 18th Party Congress. In any case, it's so fun to get to see my Zhengfa Wei colleagues in person, and then after this very rich and stimulating conference, the last couple of days that Harry Daucher did so much to organize, and the Fudan UC Center, to be able to share with all of you the work that I'm doing on Chinese legal and judicial and administrative law development. So I think usually it's about an hour. Is that right? So maybe I'll speak for about 25 minutes, and Delighted to see my friend, Professor Yan Long from Berkeley here as well. So I'll speak for about 25 minutes. I'll share with you kind of what I'm thinking about in this working paper, and then I think maybe Victor will have some comments, then we'll just open it up. I don't have slides. I know that oftentimes speakers, especially here, will use slides. I come from a law school setting where that's not as much our convention, so I hope you'll forgive me if I'm not using slides. And my research and my methods is a much more qualitative approach than I think maybe is most of the speakers that you will have here, or some of your colleagues here. One of the things I've thought a lot about over the last couple of days is kind of the qualitative versus quantitative, and it's an old sort of discussion, and it's not something that I necessarily want to rehash right now, but I do want to just be clear that my method for many decades of really studying Chinese law and associated topics around the judiciary, administrative procedures has been a much more qualitative approach. Very deeply interview heavy, and I've spoken to lots of different legal actors throughout the country very systematically, but that's where my insights come from, and that's what I'm sharing. And I think, to the extent that a theme that I've been thinking a lot about after this conference the last couple of days is the connectivity between qualitative and quantitative approaches. Maybe that could be something we address in the discussion afterwards. I think perhaps like the best new scholars, certainly maybe Chinese politics, but also other fields of social science inquiry could possibly combine these kinds of methods to tell data-driven, rigorous stories, but that are embedded in a wider qualitative understanding that I personally think is very important. So what the paper I'm working on right now, what I'm basically trying to do is take stock 10 years later of this really, in my view, significant inflection point in the story of modern Chinese legal development, especially since the Cultural Revolution, which was the decision and associated activity around the Fourth Plenum of the 18th Party Congress in 2014. This was called the Rule of Law Plenum. It was a kind of a focal point for a lot of legal reform activity up to 2014. It reflected the best thinking of what I will oftentimes refer to as the legal reform community in China. Now, 10 years later, 10 years is a nice round number. It's a good kind of anniversary date. We can think about, well, how does it look in 2024? Was the promise that some of us, and including myself, saw in that document in 2014, was it actually realized? If it wasn't, why not? And what could the next steps look like? In order to tell that story, I have to do maybe just like 2 or 3 minutes of just a little bit of like background introduction to the story of modern Chinese legal development. I'll try to do this very quickly. And the main point to start off with is just that in the aftermath of the Cultural Revolution, where of course everyone in this audience is very expert on China, knows how much Chinese institutions suffered during the Cultural Revolution, there was this major push coming from the very top to develop a legal system that could set aside some of the problems from the governance of the previous period. And those of us who teach or study Chinese law, oftentimes we focus on 3 different driving factors. We talk about how one was the desire to signal to foreign investors that China had a legal system that looked like legal systems in other countries that foreign investors could rely on in making their decisions to engage in economic activity in China. There was also a desire to provide more predictability and stability for just Chinese economic actors who were contracting, trying to create new economic activity in the aftermath of the Cultural Revolution, but also something that I think is oftentimes underemphasized, but is incredibly important, is that many of the top leadership in the 1979, 1980, 1981 period had really personal suffering under the Cultural Revolution. And so there was this deep, deep understanding at the very, very top that you needed to have some kind of system to avoid some of the excesses of the Cultural Revolution, the abuses of power from that period. And so out of all of those driving factors, there's this incredible, I think, world historic period in the 1980s where you see the kind of massive emphasis on developing a legal system that looks very much like legal systems in the developed world, in a way that when you look at it at the end of the decade, it is really quite remarkable. And there's lots of different pieces to that story. It includes personnel, like who are the personnel who staff this, and many of those people, their origins are professors, many of whom had been, working in very kind of difficult circumstances for the last 10 years in the countryside. Many of those are brought back to institutions of legal education. Those institutions themselves are revitalized. Then you have the development of, or the redevelopment of institutions like the court system and the legislature and the procuracy, and of course the drafting of law. So it's a very, very robust period of time that, in my mind, is sort of, there's a way in which what happens in 1989 with the passage of the administrative litigation law, the law that I spent most of my career looking at carefully, kind of symbolizes everything of that decade up to that point. This law that is passed in April 1989, obviously 2 months before the June 4th incident, which formalizes procedures for Chinese citizens to sue the government. That law is a law, but it's also embedded in that is kind of an account of all the thinking about what law meant, what the relationship of law and political power was leading up to 1989. And of course, we know that there was this very big inflection point as of June 4th, 1989. Perhaps if the administrative litigation law had not been passed before June 4th, it would have had trouble being passed after, but it was passed before, and it was passed by the full NPC. So even notwithstanding the June 4th incident, the administrative litigation law stays on the books, and it continues to have a certain amount of vitality after 1989. So yes, 1989 is sort of a reflects a certain pinnacle in a way of 1980s post-cultural revolution legal development, but you continue to have legal development in the 1990s and 2000s, even after June 4th, 89, that is in many ways deepening what were the initial starting points that were set in motion in the 1980s. And one very small example I can give to kind of illustrate that point is when the Chinese legal scholars were thinking about a law that would formalize procedures for suing the government in the 1980s, their initial thought actually was they should have a broader law that set standards for all the different types of Chinese government activity. So a law that sets standards for administrative enforcement, and another law that sets standards for administrative licensing, and another set of procedures for rulemaking. All of that is very ambitious, and it was impossible to do in the 1980s. It was way too broad, but each of those different pieces ends up getting passed after the passage of the administrative litigation law in the 1990s and 2000s. So incrementally, the just mere fact of having a law that lets people sue the government was a kind of a bootstrap for lots of other laws passed in the 90s and 2000s that filled out that overall picture of what are the standards the government has to make its decisions based on. So that's just kind of a doctrinal picture, but around all of this, an even more interesting story to me is this development of an entire ecosystem around administrative law in particular, and then the judiciary as a particular focal point through something like the administrative litigation law and the judiciary more broadly, an entire ecosystem of professors and lawyers and judges and officials within the government apparatus. There was an institution that no longer exists, but was very significant called the Fourth Ban, right? The Fourth Ban, we'll talk about a little bit more what happened to that later, but there were legal officials within government agencies who were sort of empowered by this entire picture that's developing. So it's both the institutions and it's the law and the books, but it's also these people and their students that kind of proliferate and create an entire ecosystem. And that ecosystem in and of itself, I think, is really important and significant. All of this, and I'm kind of rushing through a lot of history because I want to get to the main points, but all of this in some ways reaches a pinnacle or a high point in the 2004-2008 period. This is often, from our vantage point today, a period that looks like a kind of a golden age of modern Chinese legal developments. And one very particular kind of story that emerges in that period that seems to reflect the degree to which the legal system has started to become something separate from politics, or at least something separate from top-down political priorities, was the emergence of the rights defense movement. So these were lawyers, mostly in the first instance, who were very much thinking how to use things like the administrative litigation law to bring government action into account, and to, in some cases, really kind of like push the needle on how much law could limit government action. So that's sort of a very, very quick and dirty background story of the story up to about 2008. Around 2008 onwards, there start to be developments that, and one thing that I think a lot about is that, like, all things are always happening at once in China. There's never any like only one story. There's always multiple stories happening. And so even in this period that I very quickly am kind of summarizing as a period of legal construction and developing kind of, check on political authority through law, there's obviously other dynamics happening at the same time. So it's never an entirely clean story. But I think many scholars, both Chinese and foreign, think that after 2008 in particular, the story of the regime being more skeptical of this kind of legal apparatus that had developed, that story starts to become a little bit more dominant. And the kind of things that people would look at in making that conclusion, one were the increasing restrictions on lawyers generally, but especially those rights lawyers that I just talked about. Also more restrictions on courts making formal determinations. There started to be this emphasis on grand mediation, as opposed to courts making decisions based on the text of the law in kind of formal adjudicatory processes. And there started to be more pressures on plaintiffs to withdraw their suits and have their cases be resolved by kind of informal, more power-driven dynamics. Tsinghua law professor He Haibo around 2011, 2012 published a very important paper on administrative litigation in particular. It's called Litigations Without a Ruling, where he was looking at how up to about 50% of administrative cases filed around that time were being withdrawn by plaintiffs. And the presumption was that this was because of political pressure. And of course, the reason I'm emphasizing this, this entire story, which Carl Minzner, who teaches law at Fordham, has most famously kind of called this period China's turn against law, that is all pre-Xi Jinping, right? That is before 2012. And sometimes people forget that, but these dynamics were all very robust before 2012. And what was really kind of interesting to many of us, including myself, who were thinking about that turn against law story in 2012, was that when Xi Jinping came into power, there were a lot of signals that seemed to suggest that there would be some kind of return to a prioritization of the formal legal system. So much so that there were even jokes that maybe China was going to start turning back towards law. And in fact, Tai-Soo Jung and Tom Ginsberg published an article in the UVA International Law Journal a few years later that had that in the title, China's Turn Towards Law. And the reason people were saying that around 2012, 2013, 2014 was partly because the rhetoric that was coming from Xi Jinping and Li Keqiang at the time about the legal system seemed to harken back to the rhetoric before the China turn against law period. It seemed to be putting more emphasis again on judges and the judicial system and formal adjudication. And then the personnel appointments seemed to be more serious, in line with if you really cared about professional, legal values. The example that many people talk about is that in the Hu Jintao Wen Jiabao period, the president of the Supreme People's Court was a former police official with no legal training. Whereas in the early Xi Jinping period, they appointed Zhou Qiang as the president of the Supreme People's Court, someone who was very much part of the legal reform community, who had studied in the first class at the first institution opened up after the Cultural Revolution, was embedded with all of those people, who had served as a governor and party secretary in Hunan, where he had pioneered certain administrative law reforms. So Zhou Qiang was like a really important kind of symbol of we're going to take the legal system more seriously. And in that period from 2012 to 2014, beyond just like appointments like Zhou Qiang and broad rhetoric about the legal system, the judiciary that seemed in line with like the harkening back to the earlier period, there was this momentum towards the fourth plenum of the 18th Party Congress, which was going to be focused on rule of law And so this strand of thinking about the Chinese legal system that goes back all the way to the early days after the Cultural Revolution, but had kind of built up even more in the 90s and 2000s around rhetoric like 依法治国, 依法行政, ruling the country according to law, administering according to law. That rhetoric and all of those ideas seem to be kind of getting this new emphasis going into the fourth plenum of the 18th Party Congress. And that decision, I think, in my work, I look at the text of the administrative litigation law as something that reflects the highest level thinking about what the legal system could do in the Chinese political context in the 1980s. The text of that communique and that decision that was issued in 2014, October 2014, out of the fourth plenum of the 18th Party Congress, it reflects the highest level thinking of that entire legal reform community that had been that entire ecosystem that I was describing earlier. There's lots of language in there that if you are not embedded in that legal reform community, you wouldn't know what they meant. It'll be very technical, but if you actually know that people were looking to, centralize funding of different court systems, to make frontline judges have more adjudicatory authority, to have review of major administrative decisions that administrative actors were going to make, to have the power of judges under the administrative litigation law be expanded. Each of those very robust reform ideas have particular language in the communique of the fourth plenum 18th Party Congress that reflects that movement. And so for someone like me who had been studying all of this stuff for a long time, that was exciting. And I know the people who were drafting that language, I know they were the people in the court system who kind of reflected that legal reform community. Now, there was also a lot of language in the fourth plenum document that talked about the leadership of the party pervading. And I'll tell you, I kind of ignored that language. I was so excited by the other language that I just was okay, leadership of the party, leadership of the party. And one of my good Chinese friends, a law professor who I've known for a long time, I was like, hey, this language is great. He's like, but they did say the leadership of the party a lot of times. And I remember saying oh, I mean, it's okay. He's like, yeah, but they didn't need to say it that many times. And so even from then, there was a little bit of signal that don't get too excited. There may be some other things happening, but I personally was I think, I'll just be admitted, I was very enthusiastic about the language that I saw in that document. And it was also reinforced by other things that were happening in the world. The Supreme Court under Zhou Chang had a very ambitious reform program, and there were lots of different pieces to it that were all being set in motion in the period right up to the communique, and then after had this new mobilization because of the decision of the fourth plenum. And so, I mean, just listing a few of those things, you had first we talked a lot the last couple of days about China judgments online, about having all the cases be online. This is all being done around 2013, 2014. All of the case transparency stuff is happening. You had a big push to professionalize the judiciary. So the many judges in the Chinese court system, they're called judges, but they don't actually have adjudicatory responsibility. So there is this idea in Chinese, the yuan of zhidu, to kind of figure out who are the real judges, make sure they have the right kind of training, give them more responsibility, and have the other people demoted to other categories. It was a very kind of difficult process within the court system, but the idea that we want to have the people called judges actually be judges and have them certain kind of training, sounds like something you'd want if you want a more specialized, more professional judiciary. You had all sorts of ideas about maybe they could move cases into other parts of the court system to reduce interference. There was a very clear understanding that official interference in cases was a problem. So you had all sorts of experiments with having cases move to other tribunals or move to higher tribunals. You had the development of a circuit court system for the Supreme People's Court, which in some ways was meant to kind of take the power of the Supreme Court in the center and take it out to the provinces. I was actually the very first foreign visitor to the circuit court that they created in Nanjing. This would have been, I want to say around 2018, 2019. And the thing that made the biggest impression on me is that the phone number for the circuit court was a Beijing area code. So it was in Nanjing, but they wanted that phone number to reflect this is Beijing. Beijing has come to Nanjing and is reflecting the power of the center here. So many things like this, ideas about how to like make sure that courts accepted cases, centralized funding. So this was a very robust period of like reform ideas. And in this conference, we had a lot of it in the last couple of days. You can see that a lot of the papers are like looking at the residues of all of those reforms, like what happened to like the personnel, what happened when you tried to systematize who the judges are, what happened when you tried to like change the way that cases are being handled, move them to other parts of the system so that you reduce interference. What happened to the China judgments online? So a lot of ideas got thrown in the mix. When we look at that picture today, 10 years later, and in my judgment on this, it's informed by I was doing lots of field work like right up to the pandemic. But then since the pandemic, I've been a few times and I've tried to understand like what happened to all those ideas back then. I think the most fair statement you could say is that stuff got really messy and some stuff got rolled back. That's pretty fair. And to kind of just go through the list, famously the China judgments online, the new president of the Supreme Court has said maybe they should take the cases down. There's a lot of ferment around that right now. The Chinese legal community has tried to push back and suggested, no, it's really important to have these cases online. And it's a little bit TBD, but at least we know that like the main, driving thrust of having all the cases go online is vastly reduced. The impact of the yuan or zhidu reforms, one, it's a little bit messy as to like whether you really have the right proportions that they had planned on of like what percentage of judges are, serving as judges. But the overall effect of maybe taking a lot of jobs away from people or making people serve as judicial assistants instead of judges, and then putting a lot of responsibility on the people who do have the title of judges has meant that a lot of judges have left the system. I think that is a story that was told again in the conference yesterday. Again, it's very hard to be very precise about numbers because, so for example, the paper says 14,000 judges have left the system, but it's hard to know, are they all people who were actually judges or were they, all the different kinds of jobs in the court system that maybe were called judges? But I can say personally, a lot of judges that I know personally have left the system and are serving in kind of capacities that are not exactly lawyers, but kind of like legal consultants and law firms. There's a lot of dissatisfaction around that. The circuit court system that I was talking about earlier, there's a lot of rumors that the circuit court system is just going to be disbanded, that people think that wasn't successful. And all sorts of these other little examples of the different kinds of reforms that have been tried by the Joe China administration, they've all kind of fallen by the wayside. One set of things that I also wanted to just say a word about is the stuff that's specific to administrative litigation. In the immediate aftermath of the 2014 Fourth Plenum rule of law, that decision, the administrative litigation law, which I said had been passed in 1989 and reflected the reform movement up to that point, the administrative litigation law was revised, and it was revised in ways that were very much reflecting what the legal reform community had hoped for a long time, including to expand the scope of review. So in the original administrative litigation law, if you were challenging government action, you could really only challenge specific government action. You couldn't say that the underlying rules for that government action were legally problematic. But in the revision, the 2014 revision of the administrative litigation law, they changed that a bit such that when you're challenging the government action, you can also, in a way, ask the court to review the legality of the underlying law or regulation. That's interesting, right? And so many of us were curious, like after 2014, would we see courts start to use that power or some of the other new powers that they were given by the revision of the administrative litigation law? And frankly, it doesn't seem like it. It doesn't seem like we have really good evidence of things like that happening. So where does that leave us? If we think about this, like really kind of, in some ways encouraging mobilization in 2014, and then kind of the wind being taken out of the sails in the 10 years since. Like what's our conclusion? Like how do we understand that? And so that's what I'm trying to play around with my paper. And I'll say a few things, but I don't want to speak for too long, and so I'll rush this a little bit too. The things that I am thinking about are one, what happened? Like, why was there this mobilization in 2014? Like, what drove that? And then, to the extent that we have this very robust account of all the ways in which those reforms have like lost steam or even been rolled back, like why? Like, why is that? And I have some thoughts I can say about that, but I just want to mark that out for now. Like, what drove the initial mobilization and then what drove the retreat? Another kind of thing that interests me is, does it matter that those reforms were put forward? Like, even if there has been a retreat from the reforms of the language of 2014, does the fact that they have been like a new benchmark was set at some level? So for example, CJO, does it matter that for at least a period of time, there were a lot of cases on CJO? And we can talk at length about the details of China Judgments Online and how many of those, you know, statistics were maybe not 100% accurate, to say the least, and how lots of cases were missing from it. But there were a lot of cases there, and now there's much fewer cases. Does it matter that for a period of time there were a lot of cases? Does that mean something in kind of Chinese political development, that for at least a period of time, people have a memory of a lot of these cases being on there? Another type of thing that I am thinking about now is, you know, I was telling the story in a way earlier of kind of like the rise of the legal system through the 80s and the 90s and 2000s and different inflection points, but it was in many ways a consistent story of development. Given all the ways in which there has been retrenchment in the last 10 years, is that original story wrong? Like, was I, and those of us, and I'm not just saying myself, those of us who were following that trajectory of that story, were we missing something about what was actually happening? Because, you know, when you see a retrenchment and such that we've seen today, it's easy to wonder, well, maybe I was missing something important. Maybe the dynamics were not the dynamics that I thought I was seeing. Maybe there was something else. I will conclude with just a couple of words that at the end of maybe telling a sort of a dark account, maybe will be more optimistic. I'll conclude with an optimistic tone and then open it up to hear from all of you. What I have often thought is the most important part of all of this, aside from, you know, the data and the cases and the statistics, all of that, is the ecosystem. The ecosystem that was kind of brought into being by the initial mobilization and the mathematical cultural revolution to develop a modern ecosystem. And again, that's the professors and the lawyers, and the judges and the officials within the government. So what I'm interested in is whether that ecosystem still has a certain degree of vitality. Are the professors still willing to speak out? Are the lawyers still willing to represent cases? Are the judges still willing to, even in the context where they now have lifetime responsibility for their decisions, like, are they willing to kind of make judgments against political power? And I think on that account, and this is informed by being back in China a few times since the pandemic, I still have some degree of optimism. That ecosystem is still there. It still has it might, you know, not be as robust as at different points that I've experienced in the past, but it still has some degree of like meaning in the world. And some examples of that to me include that during the pandemic, even at the height of things like the Shanghai lockdown, there were legal scholars from that ecosystem who were willing to write pieces that publicly criticized aspects of the lockdown in ways that I did not see in any other forum. I wouldn't say that it was a ton of legal scholars who did this, but there were more than a few, and they were writing pieces that were careful, that were strategic. Perhaps, you know, if the person was criticizing the Shanghai lockdown, they were based in Beijing, And if they were criticizing actions in Beijing, they were in Shanghai. So they were kind of being careful about how they did it. They weren't questioning regime legitimacy, but making very small, targeted interventions that particular actions the government was taking violated law in ways that were important. You saw some of that. More recently, when the Chinese government released a draft of a new security administered punishments law that had lots of provisions that seemed problematic on the face, that seemed to give frontline enforcement actors a lot of discretion. There was pushback from the legal community that said, no, these types of provisions are too broad, and they, again, didn't question regime legitimacy, but said that these types of provisions contravene very specific pre-existing laws that are a benchmark. And then most recently, the incredible pushback against the Supreme People's Court for taking cases off China judgments online, I think, again, is like a source of some optimism. And I'll just conclude with this, that that story of the cases being taken away from China judgments online has been reported on in the West as evidence that there's growing secrecy in China, and so at every level, official actors are being told to remove information from the public domain. Now, maybe there's some truth to that, but if this was really a very robust top-down instruction to remove information such that no one can see what's happening, I don't think there would have been as much space as there was for Chinese legal actors and scholars in particular to speak so robustly and so publicly about why this was problematic, so much so that the Supreme People's Court had to demonstrate that they heard that voice and at least make some kind of suggestions that they were going to maybe increase the number of cases in response to that voice. It's a dynamic that is still ongoing. I don't think that particular story, we know the end of it, but the amount of genuine, robust discussion in China in January and February around this issue of taking cases off China judgments online, I think is important. Whatever the ultimate result is, the fact that it existed and that it made the Supreme Court have to have some kind of response meant something. And to me, that kind of small evidence that the ecosystem is still alive is part of why I have some degree of positive evaluation of the types of reforms that were set in motion in the 2012, 2013, 2014 period, even if they are messy today, even if they're on life support today, they set some kind of benchmark that this ecosystem, which still exists, may be able to revitalize in the coming years if the political conditions allow. So let me stop there. Love to hear my dear friend Victor's remarks, and of course, all of your responses as well.
So I can't wait until the paper and hopefully at some point a book will come out on this issue. When the book does come out, feel free, we would welcome you to come back. So my question for you is that this ecosystem of legal scholars, especially the ones that are teaching, because as you know, one of the first things that Xi Jinping did when he took power, and interestingly, this happened before the Fourth Plenum. So there was this 9号文, I think this document number 9, where a bunch of stuff is like not okay, including what's called Western constitutional thoughts, like 西方宪法, yeah, it's like 宪政, yeah, 西方宪政 was not okay, it was going to be banned. So before this period of more harsher sort of environment, what do you think was the objective, like, of the people within the system, like the Zhouqiang and maybe people beneath? I mean, I do think that outside of the government, there were people who wanted a Western constitutional democracy, like we don't have to talk about those people, but the ones within the government, surely they were not so naive as to think that that was possible. So what were they trying to achieve for China?
So that's a really great question, and it allows me to tell an interesting anecdote, which is that even at the height of the post 2014, you had the communique and the decision from the Fourth Plenum, you had the announcement of the fourth five-year plan of that period that had lots of these ideas. You had very clear language in all of these documents about increasing judicial authority, increasing the status of the court system, increasing the power of individual judges in the court system. And at exactly that time, Jioshan gave a speech that was widely reported on, saying that we vehemently reject Western style judicial independence.
Right.
So it was like, even at that time, it was like this messaging of, that would have been like 2014. So like he gave this speech in about 2014, 2015, roughly. It was like right around the same time, and it got widely reported on. And it was just like amazing that like, it was like, okay, we're not gonna have Western style judicial, but like, look at everything else you're doing. And to me, you know, that obviously that disconnect is interesting, and it tells a story of like, you know, messaging within the system. But then, you know, going more to your broader question, I think what's really important to understand is that there are lots of different actors in this ecosystem, and some of them are more T-journey, and some of them are more T-wide. And probably there's a range of ideas from one end of the ecosystem to the other about what they're trying to do. But the middle of that, which would be, you know, not like the people who are actually the head of the Supreme Court and not the rights defense lawyers, but the people in the middle, I think they're genuinely trying to develop a body of practices and norms that make governance in China more fair, more just, more predictable, more stable. That's what they're trying to accomplish. I don't think they're necessarily trying to accomplish regime change, right? But something that, you know, that when officials make decisions, they make it according to some kind of norm that you know in advance what that norm is. And if those actions contravene the norms, that there's some kind of channel that is relatively workable, that is relatively fair, that is relatively accessible to call them to account. That's it. You know, that's all that they're really trying to do. You know, I think the intellectual question that many of us have always asked is that possible without wider political change, right? But their vision is that. Their vision, I don't think their vision is to facilitate political change. Their vision is just within the existing system to have something like that. I think that is the account that they would give.
But then what about that vision that is threatening to let's say leaders in the other parts of the government,
right,
such that even that space has been shrunken a little bit? I mean, I know you say that it still exists,
yeah,
but it has sort of deflated or shrunken compared to, you know, 2008, you know, whatever, right?
yeah. I mean, that's one of the questions that I'm, you know, that I puzzle over, and I think one way of thinking about it is just to step back and understand that what the leadership is probably thinking about at these different moments of time is just social stability generally, and to what extent, for example, in the 2004, 2005, 2006, 2008 period, there was a lot of percolating sort of activity around people's dissatisfaction on environmental issues or on land takings or on taxes. And that was creating a certain amount of instability. And my understanding of kind of the shift a little bit from the China turn against law period to the early Xi Jinping period was like the leadership trying to figure out what's the best way to manage this stuff. Is it better to have the stuff be managed by kind of like informal mediation processes, or is it better to have the stuff managed through the formal adjudicatory process? Like, what's the best way to kind of, knowing that there's a lot of things churning out of the system, like what's the best way to process those in a stable way that doesn't affect kind of like regime stability more broadly? And they're kind of like experimenting, and for whatever reason in 2012, 2013, they thought, okay, like let's put a little bit more emphasis on this, and there was a whole ecosystem that's like, hey, yeah, this is what we've been saying for a long time, like let's help them develop these ideas. But then for some reason they decided this isn't the way to do it, and they kind of pulled back the
I
mobilization.
just think it's, the reason may not be kind of like, oh, they're afraid like some big like opposition movement is gonna emerge or whatever. Maybe it's like a purely efficiency consideration because, you know, like in the US, it's like everyone's afraid of lawsuits, like UCSD being the first. I'm always saying that UCSD being the worst of, you know, whatever. It just introduces a lot of friction in the policy process. You know, because if you're trying to, you know, invest very quickly, let's say in a car factory or something, you're gonna have to bulldoze some people's homes and, you know, get things done. If they sue you, it delays the project, et cetera, et cetera. I think maybe the leadership after a while, they just think that it's like, well, this is just introduces too much friction.
And you could add that,
you know,
under Xi Jinping, there's been this big emphasis on anti-corruption.
yeah,
And maybe they were like, oh, that's the way we're going to control these local officials. We're going to control them both through our anti-corruption efforts and by emphasizing party kind of ideology and like listening to directives from the center. And maybe they just decided that, okay, that's what that's the way we're going to do. Now, of course, like there's this obviously a rich literature on police alarms, police patrols versus fire alarms. And so they decided to go all in on police patrols.
right.
And one of the questions that I think is a reasonable question to ask them would be, do you have the resources to do this? Like fire alarms are cheaper. Now, fire alarms, you might have some
Slow things down.
external effects, like it could generate like a rights defense lawyers movement, but it's cheaper. Like, do they really have the resources to keep doing this very intensive police patrol approach that they've tried to take the last few years?
Yeah. All right, we'll open it up. Isa? Yeah, go ahead.
So one of the first speeches Hu Jintao made after taking power, in that he talked about, he used the word constitutionalism. He didn't say constitutional democracy. He said constitutionalism. I think we tend to forget that for a while, when in the 90s and even the early 2000s, we hear what the policymakers and the policy advisors particularly talk, it was early on. If you look at the academic and the policy writing, there's a lot of this term gradual democracy, right? And then over time, the gradual became less important, so it became incremental democracy. So this is Yuke case stuff on incremental democracy, right? Under which you got transparency, responsiveness, all that. And then that went away. I think, around when Xi Jinping came to power. And now I think in kind of thinking about this, I wouldn't say like it was never there, but I think the imagination also has changed over time in terms of both what's possible and what we want. And then this kind of leads me to so one more thing. I think in 2014, so you mentioned like removing the CJO from the website, and I think this is amidst a bundle of different types of policy stuff. So remember in 2012, 2013, transparency became a big thing. There was this like transparency initiative. That's why all the PhD students started doing field experiments on, transparency, what does that do, and responsiveness. So this is all, I think this CJO thing, my understanding is a part of this transparency, if not responsive initiative, but it's the whole, a little bit of World Bank-y, whole set of political reform. And then I feel like maybe the going away of CJO has something to do with the going away of the Xinfang data from the website and so on and so forth. But what's really interesting here, I think, is that you talked about the ecosystem or whatever, the epistemic community in academic jargon, right? Maybe because in the area of law, because you have these professionals who actually know how to use the law, so they can challenge the decline of transparency. Whereas if it's the Xinfang, right, the peasants can't really form a community and complain why you're taking our Xinfang off the website or you're heavily censoring Xinfang data. So I wonder if there's a way of kind of looking at this in a larger comparative perspective. And this is a case in which the epistemic community or the ecosystem plays a role in kind of pushing back against this. So my question is that—
I have a lot to say about it, but keep going.
I have actually two questions. The simple question is, what word would you use? Coming from somebody who's written one paper about the law, but really won't call myself an expert on this, right? what about struggle is like, what do we call this thing in China? Is it the partial rule of law, as Yu Hua calls it? Is it rule by law, as I don't know, Mary would call it? Or is it something else? Or is it like actually we're going from perhaps the partial rule of law during the period that Yu Hua wrote his first book to rule by law? Even though I don't think, you know, I don't think right, so is it like, how would you describe this? Like, what is it when I teach the students about Chinese law? Should I describe it as partial rule of law or rule by law? Like, how do what's the best word? And I think this relates to kind of your overall conceptualization.
Yeah.
And then second question, if I may, I'm sorry for taking up so much time, is that, so I am more interested in kind of substantively, what does the law do? So I study the moral legal dilemma in the legal field, it's called the law and justice dilemma. So the idea is you have the law, but it doesn't necessarily translate into or reflect what society, what people believe to be right versus wrong. There's always overlap, but there's always tension. So then my question is, what is law doing in China in terms of shaping people's perception of right and wrong, or you know, or being shaped by those perceptions? And I think in our research on law, it's oftentimes I see this kind of tool out of the toolbox for authoritarian control or stability or legitimacy, right? But I feel like if you actually look at the cases, it's really interesting in terms of how it shapes morality or popular perceptions of justice and how it shapes. So then if that's my end goal, then what do you think the law does in the case of China? Is it to say, so like that's kind of another, you know, meta question I have about I'm really curious about how you would answer those questions.
So these are really deep and fantastic questions. And, you know, I think one way to answer it is there's a way of thinking about all of the stuff that is reinforced by or, you know, given additional weight by larger political dynamics. And there's a way of thinking about it, which is more what makes sense in this context that is somewhat separate from like legitimizing, you know, governmental approaches. So for example, maybe this point will be unclear, but I give this example. One of the really interesting, there've been a few really interesting debates in Chinese law over the last few decades. And one of the really interesting ones in my mind is the debate between He Weifang and Zhu Suli at Peking University about whether it was wrong that for a long time, local level judges were people who had not been legally trained, but had actually come from like they were retired army personnel. So, you know, this was before it was harder for He Weifang to kind of speak publicly and he had more of a platform. In the 90s, he was kind of well known for having kind of made the argument, including in piece of Nanfang Zhuomo, that it was wrong for so many Chinese judges to have be retired military, and that really judges should have specialized legal training and have been educated, and that made more sense. And even back then, Zhu Suli kind of pushed back on him a little bit, and then more robustly, once the trends were more in that direction. Now, of course, we are no longer in that world where we're even having that debate. Like there are no local level judges who are just retired army personnel. You know, they're all trained, they all have qualifications, they have to take the national judicial exam. But if you're not thinking about political power, you're just thinking about, in a local context, what kind of authority is going to help resolve disputes. You know, Zhu Suli was saying, look, like if you have some young kid who just has a legal training, that's not going to have the authoritativeness as someone who is understood as like a community leader because they're retired military. Maybe that's not a good argument for having the judges be like retired military, but again, it goes to, you can think about what is the system that makes sense for resolving disputes fairly in, you know, a particular Chinese context, and you can have that discussion in some ways without thinking of like, does this resonate with wider political power? And I think China presents a lot of these dilemmas. It presents a lot of questions where, you know, we always are thinking about the wider political dimensions, and I think for some of us are always trying to like not kind of reinforce those. But then the actual reality on the ground in China is one that it doesn't always fit neatly into like these like so I try to avoid that rule of law, rule by law, partial rule of law, because I think it's so abstract and conceptual, and it also misses that there is no like rule of law, even in like, so we say like the US, we say you sway away the rule of law, right? And of course, we know there are own challenges with that. But even if we said that in some ways the US epitomizes rule of law, it's not like something that comes from the sky. Like it's still effectuated by individuals who have been trained a certain way, who have been mobilized in a way, who like exercise discretion in a certain way. There's all sorts of discretion. When we have so much prosecutorial discretion in the US, is that rule of law? And this isn't a whataboutism argument. It's not, I'm not trying to do that at all. I completely understand that the legal system in the US is much more robust as a check on government power than the legal system in China. But it makes it really hard to use these terms. And so I prefer to not use the terms, and I don't really know that I have an alternative to that. The last thing I just wanted to say very quickly, because there's so much richness in your comment, it just inspired me up a lot of different thoughts, is one of the things that is also hard to figure out is when there's a pushback from a certain type of thing, is that for a micro reason or a macro reason? And so, for example, you were talking about the period of transparency and like the push towards like open government regulations, that did generate for a long time, and even up to this day, like lots of applications to government departments to get information on things. That, as much as we may like think it's a good thing in the macro sense, in its reality, much like these systems in other countries, the reality of that is not always as pristine as the theory of it. So, a lot of the cases that people were bringing were like business disputes, trying to find information about like, business competitors. There was a lot of lawsuits brought on these types of things that even the people in the court system who want to see the court system be more robust thought were, they said lang fei sousong, right? Like it was like, they weren't good cases. They were just people who just kept like bringing cases based on these inquiries. And so sometimes, some of the times that there's like pullback on these reforms is because at the micro level, people saw that they weren't working. And in some, like the best account of why the Supreme People's Court has pulled away from China judgments online, like the most charitable account is not that they were like responding some directive from Xi Jinping to like, let's lock down information, but that like it was really messy. Like lots of private information was getting out there. A lot of the judgments were incorrect. Like that's when you talk to the judges in the Supreme Court who are like responsible for it, that's what they'll say. They'll say to you, you don't understand how messy this was. It was like, like, does it help us to have like all sorts of decisions around the country that are all in conflict with one another? And like how does that help us? How does that lead to something? And I don't know that I ultimately have my own decision. What do I think? Do I take those at face value, or I think that the macro is part of it? But at least I think we have to think about it, that it's not always that these things were working, just great at the micro level, and it's just like the macro dynamic that shut it down.
We're out of time, but one.
Oh, can I hear? I can hear some of
these. Question. Lay, yeah, go ahead. Yeah.
So there's too many hands. I'll stop answering so long. I'll just listen.
So, well, you can take this as a comment.
Yeah.
Right? Just to follow that line of reasoning, I don't know if legal scholars, when they look at China, is it helpful to look at the legal development in domain-specific terms? That is, the rule of law, rule by law, even lawlessness, they coexist depending on which domain we're talking about. We've seen tremendous progress in terms of business law or even IP law. You talk to Mark Cohen. And in some areas like that, you can see, the rule of law exactly is real. But then in other areas, in administrative law that deals with, that has the government as party, the rule by law maybe more. But then there's a whole class of activities that are defined outside. The party is the first culprit, right? They resort to lawlessness, all this all this actually legal. That's lawlessness, right? You put all this together, there's all the things happening all at the same time. So then how do you evaluate where China is at in 2024 versus in 2014, right? So there are different regress and progress in different domains of this. And I don't know how legal scholars think of this. In other words, the grammar of law, the jurisprudence, seems to be it's hard to summarize in one singular direction.
I'll just give one sentence response.
Okay, yeah.
So my one sentence is there is a robust debate among legal scholars. Is the test the weakest parts or the parts that are the most, so do you make the test of whether, if we use the terminology of rule of law, is the test the, let's say 60%, or even like, let's make it even more, let's say, is the test at 80% that more or less are like going according to the way they should be based on the system design, or is the test the 20% that aren't? And legal scholars have different views about this. I can think of them in my mind, like they debate this, like you base it on the 80% or the 20%.
I think definitionally, rule of law actually means the government is not above the law.
Yeah.
I think like that's theoretical, but like we can have different definitions. So by that definition, then China doesn't have it, but I think like we can dispute the definition.
We got Donald Trump though, so.
Yeah.
We have well,
I have to
I'll
give
cut
you Yan.
very quickly, Wang Xin and then Yan very quickly.
Not so
Yeah.
quick, not so quick.
Just comment, I think first of all, what you were saying about how it's not just Xi Jinping, I
Sure.
think that was incredibly important.
Yeah.
Like political repression against the dissidents actually has been all going up before even he took office. I
Absolutely.
think that needs to be said. And then secondly, I think what you were saying about ecosystem, I really love that. I think that actually, I think for political scientists, I think the political regime is so important. However, for sociologists, we don't really care about so much about the elite, what they're saying. And what you were saying about the ecosystem really reminds me of what Frank Dobbin's research, he's sociologist at Harvard, about how the inclusion of minority into organizations in the United States didn't really come from bottom up or just top down. It was really the HR inside different companies. They were using it as a weapon to enhance their own career. And they became the one who utilized this to expand their territory inside the organization. So what you were saying really reminds me of that. It's not so much of ideology, it's not so much of political, it's different groups of professional for development and their own territory. So that could play a very big role in this story. I really love how it complicates. It's like everything is about the regime or is it about the different thing, and what Lei was saying, I think that every institution has contradictions. It's like different institutional logics would exist at the same time. And I think that is always important to remember. But I do wonder, like right now, there's a centralization of political logic is taking over. So it's encouraging to hear what you were saying, because I think the resource strain is a major thing. I really don't think, at least based on my own research of the COVID, is the bureaucracy no longer has resources to do it. So maybe there would be a return of the law.
And let me give you one sentence because you'll like this. So one of the things that I think is important to mention this whole story is that there has been like a top level rhetoric in support of law that is clearly kind of more top down laws control. And there's lots of different like the national supervision system that I was talking with Mike earlier about, but also there's all this like Xi Jinping rule of law thought, Xi Jinping rule of law centers, like money for Xi Jinping rule of law thinking. And one of the things on the Xi Jinping rule of law kind of like thinking and all of that I have always found to be quite fun and will reinforce what you were saying, is that I sometimes see figures that I've known what they believed in, what they were advocating from before Xi Jinping, and now they'll be invited to give like speeches at Xi Jinping rule of law programs. And so they'll give a speech that, let's say it's 10 pages, and the first 2 pages are all like broad rhetoric about Xi Jinping rule of law. And then the last 8 pages are exactly what they used to argue like for like decades before. And they're just saying Xi Jinping rule of law means exactly like support for my reform agenda, which like pre-exists Xi Jinping, right? So there is definitely a lot of negotiation like that happening. That's not at all to say that the overall context is just like easy, but there are still these kinds of dynamics within.
All right, unfortunately, we're way over time. No, we are way over time. I have another meeting.
Okay.
Yeah,
Yeah.
usually we have 1 hour.
Yeah, I'll stick around.
And then he'll answer your
Yeah.
questions. Thank you all for joining us. And next week we have another UPenn person.
Okay.
Scott
Scott,
Moore
yes.
is coming to talk
The
about
UPenn US
climate
UCSD.
change, something like that. And then actually Matt Burchin also will be here for a
Oh,
workshop.
cool.
Yeah,
Awesome.
so we have an exciting week next week. Please join us and please join me in thanking Nathan.
Thank you.